That's why on my business card and on my firm name and everything else around here, it doesn't just say Paul Brownstein attorney, it says attorney and counselor. The reason for that is because the functions of attorney and counselor are slightly different. The attorney, the official name for this kind of job that I do, is a person who's an advocate. They'll go to court. They'll represent you. They'll write letters. They'll make demands. They'll protect you. They'll file papers. And that's a very important and very meaningful part of what lawyers do. But the other part, which to me is just as important, if not more so, is the counselor part. That's where I speak to people, listen to people, and try my best to understand what their real needs are and then get them to be where they have to be so that they can get it done through not going to court, not getting involved in litigation. Because going to court, litigation, conflicts like that, that's where the cases become very, very expensive. Because lawyers pretty typically charge for their time. And going to court, things of that sort, are very time consuming. And mostly, and I think this is the truth of it, in litigation, the outcome, especially the kind of work that I do, is pretty predictable. You know, there's a number of guidelines and rules, lots of case law, lots of history in the law, and in the things like family law, custody, support, divorce, support, even adoptions, guardianships, writing wills, those sorts of things, they're pretty predictable what's going to happen, and it's a good thing they are. Because if they're not predictable, then if you see a lawyer and every case is a one-off the first time seeing it, then the lawyer is guessing as well as you are. Who needs a lawyer if he doesn't know or she doesn't know better than you might know, guessing what to do? A lawyer takes experience, knowledge you learned in school, things you learn in dealing with people, knowing what happens in court, knowing what the rules are, and applies all that to the situation the client is in. And if doing it well, will lay out for the client what is likely to happen in this case. A wise party will follow prudent advice to get to where the outcome ought to be. But then again, there are people who often have a very strong opinion and an understandable belief in what they'd like to have happen. The lawyer's job is not to tell the client you're right or wrong and only do if they're right. The lawyer's job is to represent the client. Do what the client wants to have done. Tell the client what they need to hear in a way they want to hear it. And then go get it accomplished, because it's not my job to be the client's conscience, although I'm supposed to be their advisor and let them know where they stand. It's not my job to be their parent and tell them what to do. Only what they can do, should do, could do, and the consequences of that. So when people who are potential clients call our office or come in here to see me, that's pretty much how they're going to be treated. We're going to listen to their problems. We're going to go ahead and hear what their issues might be. Figure out what the problems might be that aren't obvious, because very often what's really going on that's troublesome or problematic isn't obvious to the client. A person can come here and tell you, I had a traffic violation and I didn't do anything wrong, so I must be innocent. And that may be true, but very often what you did or didn't do isn't obviously going to cause a problem. We recently had a person who had been suspended for a traffic violation, and the court officer told him, well, not to worry about it, we'll send you your information because you've recently moved up to the Department of Transportation in Harrisburg, and you'll go ahead and get your license all restored once the suspension is done. They did their suspension. The trouble is they never got any notices of what happened next, because for reasons not exactly clear, the paperwork never got to the court, not to the office in Harrisburg. And as a consequence, he was never notified of anything that happened in this case, because PennDOT was sending everything to his old address. They didn't have another address. The point here is, if he had been to see me when it first happened, my counseling advice to him would have been, don't depend on what you think happened. The rules are you're supposed to let PennDOT know when you change your address. That means you, not a court, not an officer, not a judge, not some other individual said it, and for you to not understand that can get you the kind of trouble this person's in. Fortunately, his problem's fixable, but only going to do it in a very more difficult way to do it than it might have been if he had done this in a more careful way in the first place. When it really matters, the choice is simple.